Thank you so much. I have to use the mic because this is being recorded. Is that right? Correct. Yeah. Usually I put it down and I tell people I'm used to yelling. I have numerous children and grandchildren, so some of you may know about all of that. How many of you are unfamiliar? Is anybody here unfamiliar with the Committee on Open Government? Everybody knows? Okay. I hope you know. I hope you know. And what Anne-Marie described is good fortune. Good fortune. I suggest all the time, I have the best job in state government. I am mystified that they pay me to do what I do. Generally speaking, if I don't upset somebody in government every day of my life, it's because I didn't go to work. And in truth, I get pleasure out of it. I do. I do. Why is it the best job? I don't have a boss. I will never have a boss. If that day ever comes, I will walk. And I'll probably make them pay. And all we do is try to give the right answer under the law, irrespective of the source of the question. And as Anne-Marie mentioned, we deal with people like you. We hear from people from state government, local government, members of the public, members of the news media, especially. I'm always on the record. The phone rings, we pick it up. It's pretty simple. I hope all of you are familiar with our website. Yes? Are you? Is there anybody who's not familiar with the website? Tell the truth. All right. We have a ton of information that's available at your fingertips. Our function is purely advisory. We cannot compel a government agency to comply with law. The hope, of course, is that when we prepare an opinion, that it's educational, persuasive, that it encourages knowledge of and compliance with law. And for what it's worth, where the courts have reviewed our opinions, they've agreed probably in the neighborhood of 80 to 90% of the time. Over the course of years, and this will sound a little ridiculous, we've written approximately 25,000 opinions. And they are indexed by key phrase. One index deals with FOIL, the other deals with the open meetings law. They are intuitive kinds of indices. So if you have a question about whatever it might be, personnel matters, you click onto P, scroll down to personnel. The opinions prepared since 1993 that have any significance or precedential value are available online in full text. So use the website with impunity. Certainly anybody can pick up the phone. We always answer. The staff, by the way, is 3 of us at full strength. We are the smallest state agency that actually does anything. I leave the rest to your imagination. It is Kristen O'Neill, another attorney who's been with me just for about a year and a half, but she was the FOIL officer at a major state agency. She was able to hit the ground running. And our right arm is Candace Watson, who has been around in state government for about 20 years, so she knows how to get things done. And both are tremendously helpful to me. I am here for you. I have no agenda. I am completely unprepared. I can talk about this stuff from now until hell freezes over if you let me. But if you do, we'll miss the issues that are really important or troubling to you. So, in just a moment, I will invite you to fire away. What I hope I leave you with tonight is the general notion that both of the laws that we're talking about, FOIL and the Open Meetings Law, are based primarily on common sense. They're based upon reasonableness. All they really say, in my opinion, all they should ever say is that everything is open except to the extent that disclosure would hurt. Significantly, either somebody in terms of an invasion of privacy, the government in terms of its ability to do its job well on behalf of the public, or on occasion, a private company vis-a-vis its competition. So the real question in so many instances is pretty simple. What would happen if we had to disclose this record? What would happen if we had to discuss this issue in public? And unless the answer in the gut is, ouch, this would really hurt, chances are pretty good that disclosure should be the outcome. Now, obviously, that's an oversimplification. You want to look at the law, you might want to chat, you probably want to look at some opinions, but that is the general thrust of the law. Common sense, reasonableness. Now, I'll ask you, what's your preference? FOIL or the Open Meetings Law? No preference? What ails you? Go ahead. Anything. Yes.
Actually, a lack of transparency about our president.
Lack of transparency. You know, I was almost hoping that somebody would ask, am I doing this? Am I driving you crazy? Sun's in my eyes too. I often refer to what I have come to call the Aretha Franklin principle. Anybody know that one? What's the Aretha Franklin principle? Respect. No, that's not it. That's what everybody says. No, no. How many of you have seen the Blues Brothers movie? Everybody's seen it. You know, gross $5, 5 billion people have seen it. Best scene in the movie. Aretha as a waitress behind the counter in a diner singing, "You better think. You better think." Well, our president fails to abide by the Aretha Franklin principle, it seems, every, how do I put this nicely, every goddamn day. Every day. And, you know, here he is, and I didn't really mean to talk about this, but, you know, last night I'm driving home from work, and I listened to NPR, 5:30 News, and they, you know, it's typical news. All of a sudden at 5:37, we have breaking news. And many of you know what breaking news is these days. You know, it's when somebody stubs his or her toe. This was really news. And to be honest with you, my stomach churned. My stomach churned. Here is a guy who is, how do I put this nicely, such an egomaniac and so boastful that he was willing to tell the Russians things that probably have ruined relationships that have taken years to build with other nations. With friendly nations in particular. In my opinion, you know, the truth is you reach retirement age, you can say whatever the hell you want. And I've been there for years. He's just completely unprepared to be president. I don't know how many of you would agree or disagree with that, and I don't really care, but he proves it virtually every day. So does that sort of respond to you?
Does your agency have any relation, any pipeline to the issue that's all the way up to the White House?
No.
Through any dealings with local state senators, assembly people?
Well, you know, I should put this in perspective. There is a Federal Freedom of Information Act, which applies to federal agencies only. Every state has its own version of an access to records law. Every state has an open meetings law. They are all separate and distinct. Our law is different from the Federal Freedom of Information Act. And you probably know that in this state, we don't have an army, a navy. We don't have a national defense kind of exception. We don't classify records. We don't classify records. In fact, many of you are familiar with the phrase executive privilege. You remember that? Yeah. Executive privilege is based upon the notion that if the government can demonstrate on balance that disclosure would be detrimental to the public interest, executive privilege can properly be asserted. Well, we don't have executive privilege in our law. The Court of Appeals, the state's highest court, has said pretty simply, either there's an exception that appears in FOIL or some other statute, or there isn't. And if there isn't, no claim of executive privilege will enable the government to say no. So there are a variety of differences between our law and the Federal Act. The governor of New York, his office is covered by FOIL. You know, if he has it, it's covered by FOIL. Plain and simple. You may know that the office of the president is outside the scope of the Federal Freedom of Information Act. How did Congress ever let that happen? Yes, ma'am.
So, for example, there's reports out now that there were notes taken by former Director James Comey.
Uh-huh.
His communication with the president.
Uh-huh. Forgive me, the sun. It's not that I don't want to see you, it's just that I can't see you.
Would those be foilable?
Would they be foilable? As in any other situation, the issue involves the content of the record and the effect of disclosure. In New York, if he were an employee of New York State government, the notes would be records as defined by the law. And in fact, I should point this out because it's really important and it has had a significant impact on the course of the development of our law in New York as opposed to the Federal Act. You know, our law, well, let me give you some history. The Federal Act was first passed in 1966, effective in 67, completely revised on the heels of Watergate in 1974. And in fact, the amendments to the Federal Act were vetoed by President Ford. Can anybody remember the last time a veto was overridden by Congress? It hardly ever happens. But the public and the Congress were so sure that there had to be a reasonable right to know what the federal government was up to. Ford's veto was overridden by Congress. And that opened the floodgates. That was the year of the first version of our New York Freedom of Information law. it was completely revised by 1978. And as we were drafting those changes in the law, we looked at the federal experience, we looked at the Federal Act, and we tried to correct what we perceived to be its deficiencies. One of those deficiencies, which exists to this day, the Federal Act doesn't tell us what a federal agency record might be. To this day, there are issues that percolate through the federal courts, which involve who prepared it, where did it come from, what is its function. Those issues were all resolved here by 1978. And in truth, when we were drafting the law, in my opinion, we just got lucky. We got lucky. It was a different era. Think about 1978. Charlotte, can you think about 1978? No. When high tech was an electric typewriter, we used carbon paper to make copy. Do you know what carbon paper is? No. I talk to college kids, they have no clue what carbon paper is. There was no internet, there was no email, but as I said, we got lucky. It was the beginning of the era of computers. Computers were not the size of your phone, but the size of the table, and they could do less than your phone. But since 1978, our law in New York has pertained to all government agency records, and the term record has been defined to mean any information in any physical form whatsoever, kept, held, filed, produced, or reproduced by, with, or for a government agency. By, with, or for. Doesn't matter what its physical characteristic might be. It might be the videotape. It might be the notes on paper. It might be the database. All of those things that store information that are maintained by or for the government are government agency records. And why has that definition been so significant? Because anybody here familiar with Fort Schuyler Management Corporation? Anybody know about them? Did they do things for, State University? Huh? Yes, they did. What if the city of Buffalo hires a consultant, and the consultant prepares a report? The mayor goes to the consultant's office and says, I don't like this report. Don't ever give it to us. It's a government agency record because it was prepared for the city of Buffalo. Where it happens to physically reside is irrelevant. It's irrelevant. Anybody here ever been on a town board, a city council, a school board? Yeah, you have, haven't you? Yes. Did school board members have, offices in the school building? No, they didn't. Did they ever communicate with each other or constituents in between board meetings? Yeah, they did. And how did they do it? These days, back in the olden days, we pick up the phone, have a cup of coffee at the diner. It's all email today. And those email communications that relate to so-and-so's functions as a school board member, as a city council member, as an assistant to the governor, they're all records that fall within the framework of FOIL. And that has been, in my opinion, a critical distinction between the experience under our law and the experience under the Federal Act, as well as any number of state governments around this country. So it's been important. Questions? Yes, sir.
Can you address that a little bit more with people having cell phones, text on their own phones rather than a government-issued phone?
Well,
how you would address that and how you would get access to those records?
Well, I'm full of stories because I've been doing this for a hell of a long time. In fact, I have been told, and I have no way of proving it, I hold the record for having the same telephone number for the longest time of any appointee in the executive branch. I've had the same phone number since 1974, which means either it's a good job or I'm in the biggest rut ever created. So I'd like to think that it's the former. But your question comes up all the time, and it sort of hit the fan during one of the Spitzer scandals, when somebody called, probably from the New York Times, and said, what if somebody from the governor's office goes home, sits down at his or her personal computer, uses his or her personal email address, and communicates with respect to government business with somebody else from the governor's office at that person's home using his or her personal email address? Again, we look at that critical definition. Information in any physical form kept, held, filed, produced, or reproduced by, with, or for a government agency. those communications, even though, again, far beyond the walls of the state capitol, even though they used somebody's private computer, even though so-and-so used his or her private email address, they constitute government agency records. Whether they would be accessible under the law, again, as in any other case, would be dependent upon the content. In terms of...
You feel confident that they would give those records up?
No, I don't. I have to speak truthfully. No, I don't. I wouldn't be confident at all. There may be some things that would be disclosed, but a wise person once said to me that it seems that these days, especially, the primary function of government is to tell the public what a great job it's doing, and we all know damn well that it can't possibly be so, and it's not so. It's not so. But those kinds of communications, assuming that they are retrievable. In the case of the text message, if it's gone, it's gone. You can get it, DAs get it by subpoenaing those communications from the service provider. But if it's on your phone and you're a government employee and it's retrievable, yeah, it's a record that falls within the framework of FOIL.
How about some of these other services like photo services, Instagram, Snapchat, Messenger,
Yeah,
There's
well,
a new one every day.
let's go back to the Aretha Franklin principle. Agencies want to get into social media, and they really don't have a lot of control over what is posted on social media. And sometimes they call and they say, "Oh my God, do we have to disclose this?" And often the answer is yes, if there's no exception that can be applied. All of those things that are maintained by or for the government that contain information fall within the coverage of FOIL. What we choose to do, it seems to me, is a matter of policy, and I would like to think a matter of thought. Thought, one of those things that doesn't seem to exist in Washington. Thought. Let's think about this before we do it. Let's think about it. Yes, sir.
What about the other way?
I know I'm being mean and nasty, but it's fun.
How would you evaluate off-the-record correspondence the other way toward a journalist, for example, who needs information, gets information, and then somebody says, "I think this guy leaked something." Does that guy have the right to file for information if it's with a reporter?
No.
How do you deal with the
No,
journalist?
FOIL deals with government agency records. If the record is not maintained by a government agency, FOIL doesn't apply.
But what about confidentiality among sources, for example?
Well, we have a shield law in New York, right? There's no shield law in Washington, and there isn't in many states. But the shield law generally gives you protection in terms of your obligation to disclose. It's very rare, from my perspective, that a member of the news media will be required to disclose information that has been gained in the news gathering process.
What about the person who supplied that information to the reporter? Should one of his opponents...
Should I tell you a story? You remember Mayor Koch? Anybody remember Mayor Koch? Yeah, you remember Mayor Koch? No, you don't. No, you don't, Mayor Koch. Did you know that he gave an interview to Playboy magazine? You remember that? Remember that? That he said, "All you upstaters wear gingham dresses and drive pickup trucks." You don't remember that? Yeah, you do. Some of you do. Well, we found out that Mayor Koch kept recordings of all of his interviews with the news media in his office. Now, that interview came out when he was running for governor. And if you recall, he was involved in a primary with one Mario Cuomo, who at the time was lieutenant governor and a statutory member of the Committee on Open Government. Before that, he was Secretary of State, also a statutory member of the Committee on Open Government. And the Republican was Lou Lehrman. Lou Lehrman owned Rite Aid drugstores. The Gannett bureau chief in Albany asked me for an opinion. Are those Playboy tapes accessible under FOIL? And I was hearing from the mayor's lawyer and Playboy's lawyer, and they're saying no, 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 no. And I wrote an opinion, and it's actually getting to your point. And the notion was, Mayor, if you have them, they are records that are subject to FOIL. Obviously, the intent was to publish. What we read in the magazine was 2 hours out of about 15 hours of tape. So there was a lot of other stuff there. And My view was that the only items that might conceivably be withheld would involve off-the-record comments, and even then, only to the extent that disclosure, in the words of Foyle, would result in an unwarranted invasion of personal privacy.
Personal privacy or government policy, for example, something that
Policy, you know the word diddly? It don't mean diddly. You know, I was speaking to one of your colleagues tonight, and he was telling me about an agency's policy. Insofar as the policy is inconsistent with the statute, the law, it's of no moment.
For example, let's say he puts out there, I may go in this direction, I may go in this direction.
Yeah?
If that's public, then then he's telling a reporter what he might do,
Yeah?
and then that might fuel, give his opponents, if he says this is off the record, then it wouldn't be.
If he says it's off the record, the hope is, and I'm assuming that it's not recorded, but rather that it is speech. If it's speech, there's no record and Foyle doesn't apply. But it seems to me, and I would hope that this is so, and you know better than I, we respect off the record. We do. That's part of the deal. That's part of the deal. More questions? Yes, sir.
One of the many conversations we had when I was at the Buffalo News was Buffalo's control board. And I remember a tactic that was used, and I'm starting to wonder now if maybe we may see this more now as we're talking about transparency. The control board decided that it was going to change its committees to working groups.
I remember
and
this.
bring on some non-members so that those committees could, of course, work without any.
I wrote an
counsel.
opinion, didn't I? I wrote
You
an
did,
opinion.
And you sided with
was
the news.
I sided with the news. It was an interesting situation. And by the way, I don't use the word transparency at all, because it doesn't mean a goddamn thing anymore. Is there anybody who's run for office in the past 5 years who has not said, I'm going to have the most transparent administration in the history of the world? It doesn't mean anything. It doesn't mean anything. I don't like the word. No offense, I don't like the word. But that was the Financial Control Board, or whatever it was called. 7 members. 7 members. So in terms of the open meetings law, its quorum would be 4. If there was a gathering of 4 to discuss the business of the authority, that would trigger the application of the open meetings law. Now, the law also says that a committee or subcommittee of the governing body that consists of 2 or more members is itself subject to the open meetings law. So the authority designated a whole bunch of committees consisting of 3 of its members. And for obvious reasons, those gatherings of the committees would be subject to the open meetings law. So what they did was they designated the executive director as an ex officio member of each of those committees. And the Buffalo News wrote to me, and I said, basically, it's a sham. It's a sham. If you're going to add somebody other than a member of the governing body to the committee solely for the purpose of attempting to exclude it from the open meetings law, I can't imagine that a court would say, yep, that's fine, that's good, the meetings can be closed.
Are you seeing any trends like that? I mean, are these kind of games being played more often than in the past?
You mean that kind of game?
Yeah, or things that are similar, things that are, tactics that would perhaps tell us that maybe we're in for a real rough time.
Well, one of my favorites arose right here, and I talked about Fort Schuyler. It was created as a not-for-profit corporation, but it was a creation of the government. And they said, well, we're not-for-profit. We're not covered by Foyle. And I was asked for an advisory opinion by the Investigative Post. I did my homework. I looked at virtually all of the corporate filings. I looked at the means by which it was created, and it was clearly a creation of the government. And I wrote an opinion, and I said, yep, I think it's covered by Foyle. And they, along with the Gannett TV affiliate here, initiated a lawsuit. And what did Fort Schuyler do? Before the judge could render a determination, they said, oh, here are the records, here are the records. So the issue became moot. There was no judicial precedent. And if I'm not mistaken, they're still playing the same game. Yeah, we'll give you some of the stuff, but we're not covered by Foyle. We're not covered by Foyle. And for what it's worth, some of you may know this, a local member of the Assembly, Robin Schiminger, you know Robin? Robin introduced legislation based upon a recommendation that was included within the Committee on Open Government annual report. which came out in December. And it's pretty simple. It would alter the Freedom of Information law by clearly including within its coverage entities that are either created by the government, that have some sort of decision-making authority, or those whose membership consists of a majority of members designated by the government. So there's no way that Fort Schuyler would be able to escape FOIL. There's no way. Whether it'll happen, I don't know. Robin, I can call him, you know why I can call him Robin? We went to law school together. We went to law school together. The world is ridiculously small. But Robin is a Democrat in the Assembly. And the bill has been introduced by a Republican in the Senate, Senator Boyle. That's the only way we get anything passed in this state. So I am relatively optimistic that it will happen. I know that the leadership is going to be talking the issue over with one of your Assembly members, who is the chair of the Committee on Governmental Operations. What's her name? With the hyphenated name. Yes. Say it again. Crystal Peoples-Stokes. I don't know whether she likes it or not, but I think if she expresses reluctance, I think you should all bang her over the head. You know, do what you do. Do what you do. Why? Why should this law not cover not-for-profit entities, at least those that call themselves not-for-profits but are in actuality extensions of the government? And you know, I've used a terrible metaphor. You know, if you look at the sky and it's blue and you call it green, it's still blue. It's still blue. And it's the same with these I call them dummy not-for-profit corporations. And we see them all the time. The other thing that comes up all the time, have any of you referred to quasi-governmental entities? Like what?
LDCs.
LDC? Yeah, well, you know.
Auxiliary corporations at public universities.
Oh, those. Yeah, we could talk about that for a while too, but I hear about industrial development agencies, things like, they're not quasi-governmental. They are government. They are government. Anytime you look at the law and you see that it's a public benefit corporation, every public authority is a public benefit corporation. It is clear that FOIL and the Open Meetings Law both apply. They both apply. Yeah?
Beyond the lawsuit that you mentioned in relation to Fort Schuyler, is there any advice you could give us on tactics?
Oh, absolutely, absolutely.
For trying to get information.
I refer, well, first of all, you use the authority that you've got. You have a great deal of power. You have the power to encourage, you have the power to embarrass. And I don't think you embarrass the hell out of government nearly enough. I refer to a statement offered by Judge Louis Brandeis about 105 years ago. Sunlight is the best disinfectant. I really believe that to be so. And the more you shine the light on whatever it might be, usually either good things begin to happen or bad things stop happening. You shine the light. You shine the light. Now, I have to say something to you that you're not going to like. Phil, you know, you're going to tell me one of these days that they won't talk to me. Government officials don't have to talk to you. They don't have to talk to you, but they are required to respond to requests for records. That's part one. Part two, in so many instances, they are associated with so-called public bodies that are covered by the Open Meetings Law. Let me ask you, when you go to a meeting and they're about to go into an executive session, what's the favorite word that they use? Personnel. Who said that? Personnel. Personnel. You know? Well, first of all, I've come to call it the personnel myth. How many of you have ever heard or read something like, oh, it's personnel matters, confidential, can't talk about it, There's no law that says that. There is no law that says that. But too many Americans have become stupid and sheep-like. We hear these things over and over and over again, and we begin to believe that they're true. I mean, look at the result of the last presidential election. It's proof of that. Nobody even snickers? Nobody even snickers? Please. You look at the 8 grounds for entry into executive session in the Open Meetings Law, the word personnel is not there. It is not there. You read FOIL from beginning to end. Oh, it's personnel record. The word personnel doesn't appear anywhere in FOIL. Now, think about personnel matters. There are 1,000 kinds of discussions that might constitute personnel matters. Some of them may be discussed in private, some cannot. That's why I suggest to reporters and others all the time, if you cover public bodies, bring your copy of the open meetings law with you. Why? So if you hear the word personnel, you can get up and say, wait a minute, board. Here are the 8 grounds for entry into executive session. Please tell me where this fits. And sometimes that will open the door and enable you to share the information with the public that otherwise might never come out. Now, let's talk about that exception. We just finished school board budget season. What if the school board says to itself, things are kind of tight this year. Can we really afford, do we really need this art teacher position in the elementary school? What if there's one elementary school and one art teacher? Everybody's going to know whose position it is, right? Huh? What do you think? Executive session? No, because the issue involves policy. How do we, as the governing body of a public corporation, choose to allocate public money? Is art really important to the education of our kids? Certainly it's a personnel matter, but there's no basis for entry into an executive session. On the other hand, if the question is, should we keep this teacher or can this teacher? In that situation, in the words of the law, the focus is on a particular person. And the law says, and I'll quote, that a board may, not must, but may enter into an executive session to discuss the medical, financial, credit, or employment history of a particular person. I'm losing the crowd here. I can't believe it. Excuse you. Medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So to qualify for entry into executive session, the issue must focus on somebody or some specific corporate entity in relation to one or more of those qualifiers. Now, you know, I hope you know, that before an executive session can be held, a motion has to be made in public, and it has to indicate the subject. Well, if they tell you they're going to discuss a personnel matter, do you have any reason to believe that they're complying with the open meetings law? No. The courts have said that is not good enough, and in fact, they have cited our opinion, which has suggested that the motion under that provision should include 2 elements. Number 1, reference to the keyword particular, so that we know that the focus is on somebody. And number 2, reference to one of those qualifiers. I move to enter into executive session to discuss the employment history of a particular person, or something like that. They wouldn't have to name the individual, but if they tell the world that much, what they're really saying is, yep, we've read the open meetings law, and unless we're fibbing, yep, we're about to discuss a subject that can properly be considered during an executive session. Yeah?
What if they discuss other things during that session?
Well, then they're failing to comply with law. If they have more than one basis for going into an executive session, the motion can include 2 or more.
How would the public know that?
How would the public know? You're a reporter, right? Yeah? Yeah? You know, this is awful. This is awful. You know, what they do in so many instances, they go into an executive session and they say they're going to discuss topic X, and they drift into topic Y. It's human nature. It's human nature. My suggestion to reporters is that you use one of the rules of human nature. And the rule is that there's somebody on virtually every board who's willing to spill his or her guts after the fact. And it's your job to find that person. It's your job to find that person. And, you know, it's not like classified material. You know, generally speaking, there's no law that would prohibit so-and-so from talking. Whether it's good or wise or ethical is separate and distinct from whether it is contrary to law. Contrary to law. And we hear this all, yeah.
So it's not illegal for somebody then to say, well, in this executive session, we addressed this outside of this personnel matter, and it's fine. That person can't get in trouble for...
Well, let me ask you a question. Which is less ethical? Discussing something in private that should have been discussed in public, or divulging what should have been discussed in public in the first place? I think it's an easy one. I think it's an easy one. Yes, Daniela. Daniela calls me almost every day. I don't know why. We
Just enjoy our home.
Is that it? Okay.
Yeah. So.
You are
I know we
turning a
talked
little bit colorful.
about this
Yes.
yesterday.
Yes, I don't remember
in
what we
our
talked
daily
about.
phone
On our daily phone call, yeah. Recalcitrant?
delaying,
Yes,
but legally, not that legally, I'm going away on vacation, I've been away for this number of weeks and haven't gotten to your FOI. How would you approach that?
Well, I'm not suggesting to you that agencies have to jump in response to a FOIL request. They don't. What we discussed yesterday was the function of the so-called records access officer. Every agency is required to designate at least one so-called records access officer. And as I mentioned to Daniela yesterday, that person's function is to coordinate the agency's response to requests for records. That means if he or she is going on vacation for 3 weeks, that doesn't mean that the clock stops ticking. It doesn't mean that the agency should ignore the request. What it does mean is that he or she should arrange in some way to have somebody else deal with the FOIL request, if only to acknowledge its receipt and offer an approximate date indicating when they believe they'll be able to answer the request. But to say I'll be out for 3 weeks, nothing's going to happen, to my mind, that is simply, it's a failure to comply with law.
And if they keep sending you notices, like we need 20 more days, we need 10 more days.
Well, let's talk about that too. Anybody ever experienced that? Yeah. 3 strikes and you're out under FOIL. And someday somebody's going to sue the hell out of somebody and it's going to go to the Court of Appeals. I hope it goes to the Court of Appeals. Why? The law says that when an agency receives a FOIL request, it has 5 business days from the receipt of the request to do something. Within that time, it might say, yep, you can have it, here it is. That would be miraculous, wouldn't it? Yeah. Or it might say, no, sorry, you cannot have it. In any case in which a request is denied in whole or in part, you have to be informed of the reason, you have to be informed of the right to appeal. And the appeal goes either to the head of the agency or the governing body, or somebody designated by the head of the agency or the governing body. Second option, for whatever the reason, the agency needs more than 5 business days. In that situation, its obligation is to acknowledge the receipt of the request in writing within that time and to offer an approximate date, generally not to exceed 20 additional business days, indicating when it believes it will be able to grant the request in whole or in part. Third option. It's an unusually difficult, complex, extensive request, and they need more than 20 additional business days. In that situation, the agency is required to explain why it needs more than 20 business days, and it must provide what the law refers to as a date certain, a self-imposed deadline. Yes, we promise, we swear, we'll make the records available in whole or in part by such and such a date. No more extensions beyond that. No more extensions. And in fact, let's talk about this in a little bit different way. Let's say that you make a request, 5 business days go by, and the agency has done nothing. You have the right to consider the request to have been denied in that circumstance, and that gives you the right to appeal. And the appeals person or body has 10 business days to do one of 2 things, to make the records available, or in the words of the law, to fully explain in writing the reasons for further denial. Let's say that they give you the acknowledgement, 20 business days, time has come and gone. Same thing. It's a denial of your request, you have the right to appeal. Same in the case of the date certain that is passed. You appeal, maybe they answer within the 10 business days, but what if they don't? You can go to court if you want to go to court. I'm not suggesting that that's a good option, but you have the right to consider the appeal to have been denied, and you can bring a lawsuit. Now, under FOIL today, let's say that you bring a lawsuit, and in the words of the law, you substantially prevail on the merits. In that situation, the court has the discretionary authority to award you attorney's fees payable by the government if it finds either that the agency had no reasonable basis for withholding, or if it failed to abide by those time limitations that I just mentioned a moment ago. Now, significantly, there is a bill which has already passed the Assembly, and I'm told it's going to pass the Senate, introduced by Senator Gallivan, who is not far from here. Bang on him too, and bang on the governor after it passes the Senate, but it would deal with the situation where the agency engages in what I've come to call the Nancy Reagan response. Do you remember that one? Just say no. Where the agency has no reasonable basis for withholding, the award of attorney's fees would become mandatory. Mandatory. And the idea is not to sting the government, the idea is to encourage compliance. So, I'm hoping that that will become law soon. Yes?
I'm finding that a lot of agencies will list that they have like an email for the FOIL officer. but
Yep.
It's like this mysterious unknown FOIL officer you're dealing with.
Yeah?
Do they have to tell you who the person is?
Sure. Sure. Why would they not?
I agree.
Yeah, of course they have. You know, that leads me to something else. Why would they not? Would they say that it's an invasion of so-and-so's No. Remember I mentioned the clause in the law, unwarranted invasion of personal privacy? Yes? Is it something that's familiar to people? Anybody know what that means? Nobody knows what it means. Nobody will ever know what it means. There isn't a judge alive who's in a better position than any reasonable person to make judgments about privacy. And the reality is that our views about privacy as a society are constantly changing. I offer an example these days that has nothing to do with FOIL per se. Anybody here ever see the Victoria's Secret ads on TV? Huh? Yeah? Nobody has seen them? Huh? Would those ads have run on network TV 20 years ago? People say no. Well, why? Why are they running now? Because the sensibilities of society have changed. You know, what used to be so intimate, so risque, so off-color, you wouldn't have seen them on network TV. Now they're on the Disney Channel at 8 o'clock, for goodness sake. How about this? Anybody here have, what are they called, kids? Anybody have kids? Yeah. How about these kids who share information about themselves with their peers that their parents would never share? We've all heard about that, right? There are generational differences in views about privacy. And the next example I give is my favorite. Two equally reasonable people can look at the same items and disagree. I use my own life as an example. We used to have a joke in the house. If the phone rang after 9 o'clock, it was either my mother-in-law or a reporter who'd gotten kicked out of a meeting. Reporters call me mostly at work, but sometimes at night, on the weekend, at home. My name, my home address, my home phone number are in the phone book. Anybody can get them. They're in the white pages online. My wife, on the other hand, uses a different name. She'd never have that name in the phone book with a home address and a home phone number. Why? Two reasons. First is painfully obvious. She doesn't want to be associated with me. It's not that funny, come on. Rodney's dead. No, I get no respect, you know. Second, she's a psychotherapist. She doesn't want her clients calling her at home on her home phone number, knowing where she lives, knowing that she's married to me, knowing that at certain times of our lives it has seemed that we have too many kids. She has perfectly good and valid reasons for saying no, never. I have equally valid reasons for saying I don't care, and never the twain shall meet. So what do we do about privacy? Well, the courts have given us some guidance. I'm not saying that it's fabulous guidance, but when the government maintains a record that identifies an ordinary person, the courts have pretty much said, doesn't work. React from the gut. What would the reasonable person of ordinary sensibilities feel about disclosure of this item? Is it one of those things where the average person would say, wait a minute, this is nobody's business, this is intimate, it's highly personal? If that's the reaction, chances are pretty good that the government either may or must say no. Yeah.
So how do you feel about Snowden, WikiLeaks?
Well, that's sort of off the track, but I'll go there if you want. Snowden and WikiLeaks. You know, actually, there you're talking about federal law, and it's not something that I know a heck of a lot about. But, because people call and I answer, even on public radio, yeah, they call. My feeling is that WikiLeaks, Snowden and Assange are different. Snowden and Assange are different. If we're talking about WikiLeaks, Assange, if he comes back to this country and he is arrested, that would be the end of the First Amendment. I suggest this all the time. If you get it, in fact, I'll tell the story. there was a young reporter, not terribly far from here, in between here and Syracuse or something, I don't know, called me one day, and she said, I went to the county clerk's office to request records, and they gave them to me, but by mistake, they gave me the detailed records involving a divorce proceeding. Those records are confidential, and it happened to have involved a state senator. And she said, what can I do with them? And I asked her, did you steal them? She said, no. Did you acquire them illegally? She said, no. I said, you could do whatever the hell you want. Whatever you want to do. And she was nice. She called the senator. He said, I don't care, even though part of the record indicated that he pulled the gun on his wife. And by the way, he still won re-election. Assange didn't steal them. The records were leaked to him by Private Manning. Manning is the one who's in jail, right? Manning is the one who had no authority as a government employee to disclose. But, and of course, what do we hear today from the Trump administration? It's those rotten reporters who don't respect, security or whatever it may be. They shouldn't have told us what they told us. If anybody violated the law by disclosing, it would have been the government employee. What the Times or the Post or NBC might do with it once they get it, that's up to them. That's the essence of the First Amendment. Snowden, on the other hand, was a government contractor. He had no authority to do what he did. The question that I have and that so many people have is, did he do the right thing or did he do the wrong thing? And, for a long time on my way home from work, there was a sign that said, Snowden is a hero. Whether you agree with that or not, I don't know. But I think he did tell us things that we really should have the right to know. Sometimes we do engage in what used to be called civil disobedience. Remember that? Civil disobedience. Yeah. I found out, by the way, not long ago that my wife and I were on the same peace march in Washington in 1969, several years before we met. Yes, civil disobedience. It's fun. We were talking about privacy, weren't we?
Yeah, but I mean, what he did was let us know just how pervasive this government arm is.
Oh, yeah.
And I think, I personally feel we had a right to know as a people.
I agree with you. And think about this, going back to Assange, who leaked something like 400,000 records.
I'm talking about Snowden.
I know you're talking about Snowden, but Assange, this country classifies way too much. This country classifies millions and millions of records every year. A lot of them are just crap, And do you know who can classify records at the Department of Homeland Security? Anybody. Are they all completely trustworthy? Probably not. Yes.
I've been covering a lot of education into a lot of schools. We've been setting up these cafeteria chats. And I was with a group of P-Tech students, which are taking technical classes and are separate from their high schools. And we had groups set up, and we had some adults from the program sitting in there. And the one student identified herself as gender neutral. And when I started to ask her about the transgender policies with bathrooms and locker rooms, I was immediately told, Eileen, no, and she tried to shut it down, and she was on the phone saying that I broke the school law.
Who broke the school law?
That I did.
You did. You can't.
Exactly.
You can't.
So the student piped in and said, I want to answer that. And we moved forward with our interview, but they were very upset with us and berated us for asking that, and that we're not.
Do you care about being berated?
No,
No, of course not. Of course not. Look, and this kind of issue comes up all the time. Just to put this in perspective, the Open Meetings Law gives the public the right to be there, to attend, to listen, to observe. It says nothing at all about the public's right to speak during a meeting. If a board wants to say, sorry, nobody can talk, that is its right. Often, members of the public have said, I have a First Amendment right to speak at the meeting. Not true. You have a statutory right to be there, but no First Amendment right to speak at the meeting. But certainly you do have the First Amendment right to stand on the steps of the schoolhouse and say whatever you want. Or these days, establish your own blog or website or whatever it might be. And certainly the student could have done that, and I'm always curious to see what kind of retribution might be attempted with respect to the student. That's why we have, civil rights actions where people get $1 million and more and more. It's interesting. And the other point to make, how many of you cover school board meetings? Not too many. You know, I live in what I've come to call the Stepford School District. Actually, it's a great school district, but is there any school district where they don't tell you, oh, you know, all of our kids are above average and all the teachers are wonderful? That's what every school district tries to tell us, and we all know that it can't possibly be so. Just like in whatever the school district was where you were, nothing bad ever happens here. And, you know, I suppose in the eyes of some, this notion of, you know, identification as being transgender is somewhat, I don't know, it might be stigmatizing in the eyes of some, it might be distasteful in the eyes of others.
You just mentioned the statutory right to be there.
Yes.
Can a public entity, if it's streaming, physically keep you out, keep the public and the media out of the meeting, similar to the recent train selection committee that did that this spring?
Well, that was a different matter. The open meetings law applies when, I mentioned this earlier, when there is the presence of a quorum of a public body. And my understanding is that there was no quorum in that instance of any particular public body. You could have all the big shots in the world there. You could have the governor and the president and the senator and the this and the that talking about whatever it was, but if there's no gathering of a quorum, the open meetings law simply doesn't apply.
If they had the quorum.
No, if they had the quorum, anybody would have had the right to have been there.
Physically, though.
Physically.
Physically, you can't just say, because that's what they were saying the day before.
What were they
when
saying?
we thought there was a quorum.
Yeah.
No, this complies, this was the mayor's office, this complies with the regulations.
Do you know why they said? Because they didn't have an idea what the law says.
Yeah.
It complies. It complies with nothing. There's no law that dealt with their situation. There's no law
So
that
if
says
there's a
it.
quorum,
If there's a quorum-
you must physically be allowed to be in that room. You can stream.
That's
all
what the
you
law
want.
says.
Yeah.
That's what the law says. And in addition to the entity streaming, and I hope everybody knows this, the open meetings law says that anybody can audio record, video record, or broadcast an open meeting so long as the use of the equipment is not disruptive or obtrusive. That's been the law now for several years. There was case law that indicated all of that way before the language of the law was itself amended. Fight it out, you two.
We've been both dealing
Is anybody else in here warm? It's blazing. Yeah. Maybe it's me. I don't know.
Most board meetings I've covered, the setup is a lot like this, where you have the public waiting for the board to get in there and they start the meeting. We've been covering these meetings at MCCC, and it's a complete opposite, where they make the public, so the meetings are held in a conference room off of the lobby of the presidential suite.
Presidential suite?
Yeah.
Which empire are we talking about here, right?
And but they make the public stand out in the hall, and they close the door beforehand, one by one, all the board members, go in and they sit down. Are they allowed to do that once they have a quorum, to stop people from coming into that room?
Once there's a quorum, anybody can be there. And one of the basic principles underlying both FOIL and the open meetings law, who you are, where you're from, make no difference. You could be from Timbuktu or Buffalo and have the same right to request and obtain records, the same right to attend meetings of the city council. Sure. Yeah, Phil.
Bob, we discussed using personal devices to make government communications. We talked a little bit about the LDCs and the auxiliary corporations. Is there anything else coming down the line? Any creative ways to keep records or keep communications from the public that you're hearing reporters talk about?
No, I mean, I keep mentioning the critical definition of the term record. What is it that they could do that would remove the operation of that definition? If it exists in writing, in some physical form, or if it's, again, a videotape, if it's email, if it's a database, it's covered by FOIL.
What if it's a text message on a personal phone?
Well, again, is it a text message that involves the performance of so-and-so's duties? If it is, and it's retrievable, it is indeed a record.
But I think that's a huge hole that's developed in the law.
I'm not going to disagree with you. And I
It's
think
getting bigger and bigger, too.
well, it is getting bigger and bigger. And we're going to have to challenge them more and more and embarrass them more and more.
Is there any case law or something we can point to, when we make these requests and say, look, this is why you have to, this is why you're allowed to look at a personal email?
You go to our website, write down 15893. 15893. That's the opinion that I cite all the time to deal with the question that came to me then. What if a town board member sits down at his home PC in his home and sends an email to another town board member? It does FOIL apply. It's there. It's there. It's there. Use it. Use the opinions with impunity. Stick them in their faces. Yeah.
What's one of the most interesting things you've seen come back from a FOIL request? For an example, a while
Come
back.
back?
So, I don't know if anybody is familiar with this, but there's a website called Muckrack.
Yeah, I know Muckrack, yeah.
Actually, is it Muckrock?
Whatever.
Not Muckrack. Anyway, they make a habit of sending strange FOIA requests, putting them up online, and they've done things like they FOIA'd the cafeteria complaints at the CIA. And they got a bunch of agents coming back and claiming the kielbasa is a little bit undercooked, and the corn's cold, and that sort of thing. I'm going to.
I have no way to answer. I can talk about denials of access that I thought have been strange. Where the request is for the records involving who knows what dog bites. Unwarranted invasion of the dog's personal privacy. Well, no. You had a question in the back, yeah.
Yes, as a member of the media, outside of being really unprofessional, what could we do that would actually get us in trouble?
In trouble? You print fake news.
I mean, okay, I know that, but sitting in a meeting or something like that, and we have access to things because they have to give us information, things like that. We have shield laws.
Yeah, but your rights and your obligations are the same as any member of the public. If you're disruptive at a meeting, for all I know, you might be arrested. I don't know any reporters who have been arrested for being disruptive. Maybe you do. But there are certain members of the public. Every community, you all know this, every community has its local lunatic and or obsessed person, and they are just, in some instances, beyond control. And on occasion, what I suggest to a town board where there's somebody who's out of... You have a big cop standing in the back of the room like this. And usually that's enough to maintain a degree of decorum, let's put it that way.
Are we allowed to discuss personnel here, or is this off the record?
You could talk whatever about you want. I told you that. I know you are. Say anything you want.
I wanted to ask you about cameras in the courtroom from where you sit.
The courts are not covered by either FOIL or the Open Meetings Law, but you should know that most court records are available under other provisions of law. It's relatively rare that court records are out of bounds. In terms of cameras, we have an old section of law. It's been on the books since the 50s, Section 52 of the State Civil Rights Law. And basically it says that cameras, that recording devices cannot be used in any proceeding in which a person is or may be compelled to testify. So that's all trial court proceedings. That's why you can see videos of proceedings of the Court of Appeals and the appellate courts. There are some trial court judges who have said, that provision is unconstitutional, I'm going to let you in. But not all of them. And New York, despite being the media capital of the world, is an aberration. The great majority of states, it's over 40, do permit some limited use of cameras in...
Why should the camera be any different than the pen, for example?
Look, I agree with you completely. I agree with you completely, especially somebody said the cameras are everywhere. They are. They are. It's silly. It's silly. One of the realities, I think, is that the Trial Lawyers Association was opposed to the legislation, and they gave a lot of money to Sheldon Silver. He's not there anymore. Whether that will make a difference, I don't know. And I haven't seen a push for it this year. Have you? No, I haven't seen a push for it this year. Yeah.
What happens to the Committee on Open Government after you leave?
Oh, please. I don't know what the answer is. The reality is that Kristen in my office knows the law cold, but the other reality is that she does not have the same kinds of relationships that I've developed over the course of over 40 years. And realistically, I admit it, I get away with all kinds of stuff. And the governor's office knows it, and they leave me alone. They leave me alone for two reasons.
What kind of stuff do you get away with?
I disagree with them in public all the time. I write opinions that they don't like. I even show them to them first sometimes, say, you know, if you're sued, you're gonna lose. You have nowhere to go. And they take their chances. Lots of agencies take their chances. So why do I get away with it? I'm not exactly sure, but number one, my first real boss was Mario Cuomo, and when he was Secretary of State in 1975. And he was a lawyer above all, and if he thought that I was correct on the law, he was completely supportive. And there were even times when he said, you know, you're not yelling loudly enough. Imagine that. Second, and I think that this is reality, and I'm not saying it to butter you up, I think there's a recognition of the nature of the relationship between me in particular and the news media as an industry. They know. And I don't say this to sound egomaniacal. I don't know of any other state employee who can pick up the phone and talk to you just because the phone rings. How many of you have tried to deal with state press people? Yeah, they can't talk to you anymore. They cannot talk to you until they get some sort of clearance from the governor's office, and by the time they do, it's either wrong or it's too late, or it has the spin that they want. I think it's not a good way to run a government. But, you know, I'm not the governor, and I never will be. People have said you should become a judge. Well, I'm 3 weeks away from mandatory retirement age. Not going to happen. And it wouldn't happen also because when you upset somebody in government every day of your life, you just don't get to become a judge. Pretty simple. What will happen, Phil, in all honesty, I don't know. Some of you may know. You probably know. I probably told you. I retired. Any of you know that? I retired and came back 2 days later. For an honest to goodness, valid reason. Most of you don't know this. There's no reason for you to know it. But when I joined state government, I became a member of Tier 2 of the state retirement system. And in Tier 2, if I had kicked the bucket suddenly, my wife would have gotten no pension. So I had to retire to protect her. I did. They rehired me. They're paying me, you know, crap, but I don't really care. You know, my new salary is the difference between what it was and my pension. So I'm bringing home the same amount of money. Taxpayers are saving a chunk because the lion's share of my income is from the pension system. And nobody's going to read about it in the New York Post. It's not the kind of double dip that really is newsworthy. So here I am. And, you know, as long as I feel good, as long as I don't have a boss, I see no reason to stop. My wife, too, is working full-time. We are the last in our peer group where both spouses are working full-time. They think we're crazy, but, you know, I don't know how many of you are retired, but there are so many retirees, they stub their toe in the morning, it's all they talk about the whole damn day. We don't want to be like that. Yeah.
Question on the open meetings. Now, with electronics, and it's now so easy to Skype and teleconference, if you've got a 5-person town board and 3 of them are teleconferencing and they can see each other, they're all in their own homes.
Yep.
Is that an open meeting?
Yeah. Now you said teleconference. There's a big
Or video conference?
No. There's a big difference between the telephone conference as opposed to the video conference. And in fact, there's a story there too. And, you know, who remembers this from 1990 or 92 or whatever? We put out an annual report, we make recommendations. And the question was, how do we use the technology to improve the operation of the open meetings law? Should we recommend that the law permit meetings to be held by telephone conference, video conference? What do we do? Well, one of our members at the time happened to have been on a city council. And he said, gee, wouldn't it be great if I could participate by telephone from my living room? Number one, I wouldn't have to face my constituents. Number two, nobody would see who's whispering in my ear. That's why we recommended that the law be amended to permit meetings to be held by video conference. And if you notice, at the beginning of the open meetings law, there's a statement of intent, and it refers to the public's right to observe the performance of public officials. So technically, if you have members actually, our committee meetings are held by means of video conference. 2 of the members are here in Buffalo. There are others in New York City and others in Albany, and, you know, it works. And it works fine. As long as everybody in all of those locations can observe one another, it's a valid meeting.
What if you've got
You know, it hasn't come up, and I suppose we can all have great imaginations. I hope it doesn't come up, but as long as members of the public have the right to observe all three and have the right to attend at any location where any of those three may be participating, yep, that's a valid meeting. In fact, you know, there are some ritzy communities down on Long Island where there have been more people at the condo in South Florida than at Village Hall back in Suffolk County. Yeah, you know, as long as the notice indicates where the members are participating, that anybody can attend at those locations, so be it. So be it. Yeah.
What if there's, like, you know, say 5 people on the city council and you're discussing policy between meetings and there's like all 5 of them are on an email chain, say?
Comes up all the time. Comes up all the time. The president of the council sends an email to all the others. One member sitting in front of his screen sees it right now. Another one will see it tonight at 9 o'clock. A third won't see it until tomorrow. He's out of town. Our view has been that the open meetings law is not implicated in that situation. It's really no different from the old-fashioned interoffice memo. Each piece of mail would go into the mailbox at the same time, but the members would all open the mail at different times. And I don't think anybody would argue that that flies in the face of the open meetings law. On the other hand, if a majority happens to get together via chat room, instant messaging, by phone, whatever it might be, there's no doubt that a court would say that that violates the open meetings law. Okay? Yes?
Can you speak a little bit about?
You know that I can. You know that I can. Oh, okay.
About how to deal with requests involving investigative files like police records that pertain to an.
Where did you get that phrase, investigative files?
I usually hear that.
You know, it's interesting that you mention that phrase because it was part of the Freedom of Information Law as enacted in 1974. It has not been part of the Freedom of Information Law since 1978. So if you see an agency say, well, it's part of investigatory files or something like that, you know that they are woefully behind the times. Now, as we look at the exception that likely applies in the context of your question, it pertains to records compiled for law enforcement purposes. And it says that those kinds of records can be withheld to the extent that disclosure would interfere with a law enforcement investigation or judicial proceeding, deprive a person of a right to a fair trial, identify a confidential source, or reveal other than routine criminal investigative techniques and procedures. So in every instance, we look at a verb. Where is the verb? What would happen if we had to disclose? Would disclosure interfere, deprive, reveal? You get the picture. You get the picture. And that's why in so many instances, the kinds of files, if you will, that you're talking about are likely accessible in part and perhaps deniable in part. And in fact, the Court of Appeals, I am driving you crazy. The Court of Appeals has told us that the so-called blanket denial of access, nope, you can't have anything, is inconsistent with law. It's the agency's responsibility to review the stuff from beginning to end to figure out which portions, if any, may justifiably be withheld. Yeah?
In your opinion, what's the most critically needed update to the state freedom of information?
You know, I think that the structure of the law is fine. What we really need, more than anything else, is a better enforcement mechanism. A better enforcement mechanism. You know, my hope is that if the attorney's fees provision passes that I mentioned, we'll see better compliance with law. You know, this comes up all the time. How do you improve the freedom of information law? And, you know, it should be, how do we improve it? We get leadership to take a stand in favor of access. I think that the leader, whoever it may be the head of the agency, sets the tone. You know, in this government, whether it's federal or state, local, you know better than I, you know, the chief executive officer sets the tone.
And speaking of that, of the multiple administrations gubernatorial you've dealt with, rank them. What administration stands out as being the most open, and what is the least?
Wilson had 15 minutes, so I can't really evaluate that. I thought that the best, not the most open, but the most thoughtful, the most open-minded was Hugh Carey's administration. Yeah, by far. You know, there were disagreements, but they were honest disagreements, and there was always a debate. There was always a debate. The worst? You know, it varied. It varied. There were times when, you know, there were efforts after 9/11 by Pataki to amend FOIL in a way that would have emasculated the law. And fortunately for us, how many of you know the name Diane Kennedy? Nobody knows Diane Kennedy? I can't believe it. Diane Kennedy was one of those reporters who years ago would call me after being kicked out of a school board meeting in Watervliet or something. And she's now president of the New York News Publishers Association and has been for a number of years. Well, we have a great working relationship, and there have been many times over the course of years, and she through the magic of email, could get in touch with every editorial writer in the state and say, you know, I think you ought to know about this. I think you ought to know about this. When there was an effort, and I'm not saying that it was intentional, it was just an absence of really significant thought. You know, we got together, and you know, that was the end of the effort. That was the end of the effort, and the lesson was learned. No longer would there be an attempt to emasculate FOIL. You know, this governor talks a good game. You know, how well he plays it, that's another story in many instances, and you know that too. You know that too.
What about when the Moreland Commission was dissolved?
What about when the
Was
Moreland
it a
Commission
shock
was...
to- Was it a shock to you?
You mean, it's sort of like Comey being, you know, never mind. Never mind, I haven't seen anybody make that comparison. I'm serious, and I don't know why the comparison has not been made. You know, the first thing, when Comey was fired, my first thought was, he's getting too close. He's getting too close. And we still don't know what's going to happen when various individuals associated with the Cuomo administration are in court. We don't know yet. We don't know yet. As they say, the jury is still out, even though it hasn't been called yet.
Do you see the challenges to the legitimate news media greater now than during the Vietnam era and Watergate era?
I can't speak about the Vietnam era. There was no freedom of information law in most jurisdictions then. You know, the world in so many ways was a little bit more freewheeling. You know, I don't know what the answer. I don't know how to answer that question.
Do you think things have improved because we're at an all-time low for public trust in the media?
Or anybody else, any other institution. What institution is high in terms of I don't mean high on dope, I mean just high in the eyes of the public in terms of trust? Where's Congress? It's worse than you. It's worse than you. And I think so much of this is the sales job by people like Trump. I don't think it's true at all. I don't think it's true at all. You know, I still get 2 newspapers delivered to my door every day. Actually, those paper things. I know most people don't get them anymore, but you know, I feel naked if I leave the house without reading them in the morning. You know, and in part, in your question, reporters whimper and moan and sometimes kvetch. Anybody know what kvetch means? Yeah, some people do. That's right. Born speaking Spanish, but you know Yiddish too, yes. Of course, mais oui. Mais oui, très bien. Is it harder now to get the stuff than it was 20 years ago? Sometimes, yes. But then my question to reporters, have you been to a government agency website lately? There are things that we can get, anybody can get, that would have been difficult, if not impossible, to acquire not so many years ago. So it goes both ways. It goes both ways. And, you know, you talk about Cuomo. I mean, he has moved forward in terms of proactive disclosure. That's an awful lot that's available online that wasn't before. I don't know how many of you are familiar with the notion of open data. There's an open data executive order where many of the state agencies have placed data on their websites that you can play with. You know, you can aggregate, you can combine, you can do whatever you want. Those are significant advances. How many people take advantage is another question. Yes, ma'am.
It seems like
Sorry for calling you ma'am. I know you feel old when people say that.
it seems like a lot of the time we have a difficult time, this could be kind of piggybacking on what you were saying, when it comes to different police records. And we're fed the investigation line a lot. And I wonder if you could tell us what we have access to and what we could demand access to, and then where that line stands when you're waiting for the investigation has to report in courts and what we
Number one, I've had to say this 1,000 times. We don't have secret arrests in this country. You know, the basic booking record, as long as it's not a juvenile or a YO, typically has to be disclosed. It has to be disclosed. Number two, you think about a situation where there's an arrest. And where do people go when there's an arrest? They go to court. The more that becomes available through the court, the less becomes deniable from the police agency. The more they let the cat out of the bag via judicial proceedings, less is there an argument that disclosure would interfere with our investigation or the judicial proceeding or deprive somebody of a right to a fair trial. You know, the reality is that each case, each record in terms of its content is different. And my suggestion to you, I don't know, do we know each other?
I'm Katie Morse from jail side.
How are you?
How are you?
Well, you know, some people call me when they have a question, when they get a denial. You should too. And I'm always on the record, and I don't care who I upset. I said that earlier. Sometimes that helps, and sometimes I will give you enough so that you can go back to the agency and get them to think about whatever it may be. This notion, investigatory files, I don't want to hear that. I don't want to hear that. It hasn't been part of the law since 1977. It's silly. It's silly, and yet, why did they get away with it? Because we let them get away with it. Don't let them get away with it.
Has your office ever been foiled?
Of course.
So what's the most,
Usually it's a lunatic, you know, I mean, yeah, I mean,
reporter or reporter?
huh?
Reporter lunatic?
Reporter? No, reporters don't foil us usually. No, I don't remember a request by a reporter. You know, we get them from people who are disappointed in whatever it might be. You know, you offer an opinion that they don't like. I want to see all of your, you know, whatever it may be. You know, I don't care.
What caused you to pursue this kind of work? Something must have gotten you in the early 70s.
Wow. Actually, it preceded the 70s. I went to college in Washington in the late 60s. Never missed a peace march or an anti-war march. And that was the era of idealism. That was the time when so many of us wanted to change the world. And I'll tell you this, you know, when the night that my wife and I met, and we got married about 20 minutes later, you know, we agreed that we wanted to make a difference. I went to the School of Foreign Service at Georgetown. I expected to go into the diplomatic corps. No foreign service exam the year that I graduated, so what did I do? I did what so many other people did. Went to law school. And had a job with a legal aid kind of entity. The money fell through. Got a job with a law firm in Albany, knowing nothing and nobody. Went to Albany for a law clerk job that paid $3 an hour. Yeah, and I hated every minute of it. Friend told me about an opening at a state agency. I called, had the interview. Lasted about 30 seconds. They said, come on in. It was the end of the Rockefeller era. They couldn't stand having an empty desk. So I was hired. And there's more to the story. I don't have to go into it. But relatively soon after, this new law passed, and it created this new office. No staff, no budget, no nothing. And there are some things you never forget. Guy from the governor's office called and said, how would you like to deal with the Freedom of Information law? And I said, I don't know a thing about it. He said, that's okay, nobody else does either. But, you know, I found out soon that the basis of the Freedom of Information law is completely consistent with those days when, you know, we were rotten kids demonstrating in the 60s. It was, as they say, more or less a perfect fit. And to make things even more interesting, I was not the first executive director. There was a guy who preceded me, and he was a well-connected Republican. Hugh Carey was elected soon after. And he was terrified of people like you. He was terrified of the news media. And he had me pick up the phone. I didn't know any better. The phone rings, you pick it up. And, you know, that's how relationships and trust develop. And, you know, there have been people here in Buffalo, you know, that I talked to early on. Doug Turner was on the Committee on Open Government. Doug Turner, Murray Light, You know, I spoke to the Buffalo Press Club probably in 1978 or something like that. You know, and sometimes, truthfully, you just get lucky. You just get lucky. And there are so many times when people have said, why don't you get a civil service job? It's always been an appointed position. I've always served at the pleasure of whoever the governor might be. And they have recognized the relationship with you, with the news media as an industry, and they've left the office alone. Do you remember Sandy Treadwell? Sandy Treadwell was the Secretary of State, first Secretary of State under Pataki. And we were about the same age, and, you know, we became sort of friends. And he said to me, you know, when he was designated Secretary of State, his local newspaper, the Plattsburgh Press Republican, called him and said, number one, who are you? Number two, what are you going to do about Freeman? He didn't know me from a hole in the wall, but he did his homework, and he told me, he said, you know, we could have fired you, but, you know, we would have paid. You know, and again, I don't say this to sound egomaniacal. It's simply the way it is. And as I've said so many times, nobody is luckier than I am. Nobody's luckier than I am. You know, married to the same woman that I met on February 12, 1972. Have, you know, 5 unusually adorable grandchildren. Kids, none of the kids are drug addicts or, you know, in jail.
You gotta be damn good to last through 7 administrations.
Look, you know, has there been, could there be something better as, let's say, a dream job? You know, and the truth is, you know, government doesn't pay, they don't pay very much. I don't care. You know, and I'd like to think that I have made a difference, and all my wife does is save people's lives every day. That's all she does. So, you know, I'd like to think that we've sort of made our contribution to society. And then, you know, there's another part to this too, and I'm getting way too philosophical and theological about this. Georgetown is a Jesuit school. I was the Jewish ambassador from Long Island at Georgetown, because it was the School of Foreign Service, which even then was about half non-Catholic. But, you know, it was liberal arts education in so many ways, and I had to take philosophy courses. And the Jesuits were the liberal Democrats of the Catholic Church. And, you know, their message was community. How do you contribute to community? And without getting unctuous about this, people say, hey, Bob, when are you going to retire? And my wife's question is too, what is it that we think that we could do that would involve as significant a contribution to community? And at this point in our lives, we can't really think of anything. Yeah, I'd like to learn to play piano, but, you know, that would be nice. You know, why should I stop? Why should I stop as long as I can physically do what I do, you know, with a degree of freedom? Why not? Why not? More questions, come on. There have to be more questions. You know, what I didn't mention, the other side of the privacy issue, I hope everybody knows that the salary of every public employee in this state is public. Overtime pay, public. And do news media organizations here run the top 10 stories? Top 10 wage, I don't want to say earners, wages paid?
The news every 5 years or so does.
Do it every year. Who's at the top of the list every year? It's the cops, because our pensions are, I never earned a penny in overtime, so it didn't matter to me, but they put in 1,000 hours of overtime before they retired because we pay their pensions on the basis of their gross wages. It is a racket. It's a racket. It's a racket, and why there are no politicians who have had backbones and said, we're not going to do this anymore? I have no goddamn idea. I have no idea. And then they whimper and moan and kvetch about, you know, being in the hole in terms of their finances. You know, and it goes back in so many instances to that overtime that is paid to hundreds and hundreds of employees until they die. Why, you know? But you want to find out people's attendance records, time in, time out, leave used, accrued, public. If I am disciplined and there's a record indicating that I've done something wrong, it's public. The resume, this came up just the other day. People wanted to know, this was great. This was really great. Long Island. Anybody here from Long Island? Where are you from? Elmont. So did you go? Okay, so did you go to Valley Stream Central, North or South, or? Elmont Memorial. Okay. Well, I'm an Albanian too. I thought it was a big ethnic group. You know, we heard it the first few times. But Yeah, you know what I tell people about Long Island? It's a good place to be from. It really is. It's a good place to be from. Yeah, East Meadow High School. What class?
65.
Me too. So you're old also?
I did a few marches myself.
You're old too. I heard from somebody who said that the mayor had the Village Board of Trustees create a new position. And who was hired? His son-in-law, who lives in the same house. And so the Newsday reporter, this tells you how much freedom I think I have. The Newsday reporter called and asked, about the ethical issues. And I said, my job involves FOIL and the Open Meetings Law. It's really beyond my authority to talk about ethics. But I said, my personal belief is, if it doesn't smell good, you don't do it. And this doesn't smell good. And of course, that's what she printed. Was that beyond the scope of my technical authority? Yes. But, again, as I said earlier, reach retirement age, say whatever the hell you want. Long Island. So I suggested to her, and I hope you know this, if for most public employees come through some sort of a civil service system, there's a job description, and the question has been, is so-and-so qualified to hold the job? And we wrote opinions years ago, and they were sustained by the courts. And the general notion is that if there are certain criteria that must be met in order to hold the job, those portions of the resume that indicate that so-and-so has met those requirements have to be disclosed. Absent disclosure, the public has no way of knowing whether the government hired the right person. In addition, in any resume also that I've ever seen, you have a variety of extraneous personal information. The work in McDonald's, the hobbies, the marital status, those items could be redacted prior to disclosure of those other things that I just mentioned. Also, the courts have said that one's general educational background is public as well. Anybody here have a kid in college? Nobody does, huh? You do? What do you have on the back of your car? You don't have the sticker? You don't have the sticker. Huh. See, we used to have so many, it took 10 minutes to read the back of our car. We advertise. It doesn't rise. We can find out where so-and-so got his or her BA or BS or whatever it might have been. We can't get the grades. That is intimate. That would be an unwarranted invasion of privacy. But again, the general education background has been found to be public.
Would you say Spitzer was the greatest crisis at that level in your time?
I thought that it was kind of malarkey in a lot of ways. How many, I don't know. I don't know whether I know that the feeling, I remember the day. I was doing a program for the Utica Observer Dispatch. And at the time, my daughter lived in a newsroom. And she sent me an email and said, New York Times says Spitzer, with prostitutes or something like that. And I read it out loud, and four reporters jumped up and went to their computers right away. But that night, the OD had me do a public forum. And it seemed to be everybody's belief that Spitzer had to resign. And, to this day, I'm not sure that that is necessarily so.
Because he prosecuted prostitution rates. And it was, I guess, hypocritical.
Yeah, of course it's hypocritical. Who in public office has not been hypocritical about something? Please. I don't know that was a crisis, necessarily.
But
it was a crisis when
was
Patterson became governor.
Well, that's what I'm saying.
Yeah.
What happened?
Yeah. Patterson was better prepared than Trump.
I mean,
He was a state senator for years. He was a state senator. His father had any number of public offices. He had familiarity with the system. He had familiarity with the institutions. What about this guy who's in Washington? Anybody here really love Trump? I hope I haven't upset you too much. But then again, I don't care. Patterson and what do so many people in high office do? They surround themselves with their friends. And those are the people that they listen to. The one thing that I think is important to a decision maker is to get as many points of view, as many opinions as possible. That's how you reach reasoned decisions. You know, if you're going to listen to Steve Bannon all the time, maybe not so much. I don't know. I don't know. Crisis? What's been the crisis? I don't know. You know, most crises disappear.
I didn't get to cover Albany very often, but when I went to cover, I guess, Patterson swearing in or that, things were just, it was like being in a dream.
Oh, it was disarray. There's just no question about it. And it happened so quickly.
It happened so fast.
It happened so quickly.
Wall Street,
You know,
he's gone.
sure. And all of a sudden, there's Patterson. How many of you know? Did you know he's blind? He's blind. He's blind. Which, you know, you can't hold it against him necessarily. He's a smart guy. Again, he knew the system. He knew the cast of characters well. But he was guilty of so much that so many are guilty of. He listened to the same half dozen people and nobody else. You know, but who doesn't do that? Who's Cuomo's inner circle? Hard to know. And the circle keeps changing. It keeps changing.
It's getting small.
Yeah. Well, you know, they're on the fifth string now too. You know? Well, yeah. I mean, you know, and that's. What can I say? You know, as I said, you know, Hugh Carey surrounded himself with smart, well-meaning people. And
You
a
know,
lot.
Bill Snyder, his press secretary.
Sure.
Great guy.
Sure. You know, it was a different tone. It was a different tone. Now, in so many instances, the public is like you, the enemy. You know, Mario Cuomo, he would have reporters come into his office and they couldn't wait to leave because he would just talk their ear off. You know, does that happen today with any of them? Not even close. Not even close. You know, and Mario, you know, he was the essence, I think, of the Renaissance man. He could talk about virtually any subject at the drop of a hat, reasonably intelligently.
Would have been a good Supreme Court justice.
Would have been a good Supreme Court justice, yes. But, you know, we wonder all the time about the roads not taken. What if I had become a Foreign Service officer? I wouldn't be here tonight. But in my job, and this was mentioned, you know, you probably don't know this. In the 50 states, they all have these kinds of laws, but there are only a handful of agencies that have created offices like ours in New York. In most jurisdictions, you have a question or a problem, there's nobody to call. We get thousands of calls every year. The website now receives hundreds of thousands of hits. For years, there were only 3 of us in this country who performed a similar function. There was Don from Minnesota, Mitch from Connecticut, and me. And Don was afraid to fly. So that meant that Mitch and I have had astounding opportunities to share literally all over the world. Been to China a couple of times, Japan a couple of times, Bulgaria in February. Nobody wanted to come with me. I don't know why. Venezuela, Peru, Mexico 8 times. I think they like me better there than they like me here. And Mexico, by the way, probably has the best freedom of information law in the world. Yes. You're shaking your head. You know?
No, because you told me that.
Oh, I told you that, and you remembered and paid attention. Yeah, I love to say this. The first time I met the Mexicans was at a conference in Peru. I love to say this, right around the turn of the century. Think about that one, yeah. And it was pretty clear that 75 years of one-party rule were about to come to a close. That happened, and they got ready. And they passed a bang-up Freedom of Information law, which in so many ways moved ahead of anything that we see in the United States. So, there you have it. And they put kiosks and terminals all over the country. It was a law that was very much pro-poor. You know, there are stories about people who we'd probably view as peasants who would go to the local schoolhouse, go to the computer, tap out their request one finger at a time and get it. Wow. We should be so lucky, huh? We should. She's shaking her head, yes. You are frustrated, Daniela, aren't you? Yes. But who isn't? More questions, come on. Yes.
It's kind of a lighter question, but you and I have talked a few times, and then I've gone back to the town board and said, hey, Bob Freeman.
And they say, who the hell is he?
Or they say, we don't care what Bob Freeman says, or whatever. Just out of my own curiosity, do you ever hear from those town board people who are
Of course. You know, I'm used just like anybody else. They call me when they want to use me for whatever the reason. And if I were you, you know, certainly You know, you have the power of the pen. You print it. You print it. They might not care what I say, but when you print it, other people seem to. They seem to.
For sure.
And it embarrasses the hell out of them, and that, you know, so be it. So be it. More questions? Come on. Come on. All right, I'm going to make you an offer you'll never hear from a state employee ever again. Ask me anything. Make my day. Go ahead. Come on.
Is Trump gonna make his 4 years?
I don't think that there's a chance in the world.
What do you think will bring him down?
Do you? I think it's the Russian. I think it's the Russian connection.
What do you think it would be, Russia?
I think it's the Russian connection, one way or the other, and it'll come down, I'm guessing, to money. 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 Because that's what he cares about. Money and self-aggrandizement.
Do you think he'll ever have to release his tax returns?
You know, people have asked me that, and the reality is that there are laws that say that those records are confidential. If I go to the state tax department or the IRS and I ask for your tax return and somebody gives it to me, that person can go to jail. It's purely voluntary on the part of high office holders. Should he disclose? Of course, of course. Actually, I had a chilling moment not terribly long ago. I did a program someplace in Westchester, I don't remember where, and I don't know how many of you are familiar with the Taconic State Parkway. Yeah, well, south of Route 84, on the border between Putnam and Westchester, there's a sign that says Donald J. Trump State Park. And I said, oh my God, I almost threw up in the car. And I Googled it the next day, and I found out that he, in the early 90s, purchased 436 acres of land with the goal of building a resort or something like that. He didn't get the approvals that he wanted. And he donated the land to the state, which is why it has his name. But what is so interesting to me, he paid about $2 million for those 436 acres, and he took a tax loss of about $200 million. $200 million. And I said to myself, wow, this is newsworthy.
How'd you find that out?
I Googled it. You can find out all kinds of things online. And I called my friend at the New York Times and I said, do you know about this? And he said, no. But he went back to their records and it was in the Times, several years prior. So it was sort of old news. I think it's news that should be brought to the surface again. But I don't write the newspaper.
First of all, how can you do that?
How can he do that?
How can he take that kind of loss?
How could he do all kinds of things like that? And we heard about his $900 million loss. The latest I heard was that it was precipitated by the relationship with Russians. I don't know what's true and what's not, but it's money and the Russians that I think are going to bring him down. We'll see. I don't know. We can always hope. No, what? Huh? And then people say, oh, then there's Pence. Pence would have a completely different cast of characters. And sort of like Patterson, in a way, he knows the institutions. He is, a career government person. I'm not nearly as fearful of Pence.
Unless he's implicated along,
Seems unlikely to me, but I don't know. And then where do you go? You go to Paul Ryan. And then where do you go?
What's next after that?
I think Secretary of State.
Secretary.
There's Rex. Huh?
McConnell. Speaker, Mitch McConnell.
Oh, Mitch McConnell. There's a guy locally who refers to him as the turtle. He thinks he looks like a turtle. Sort of. Mitch McConnell, who gave one-word answers to questions today. Have you lost confidence in the president in terms of international? No. Next one, no. It's like the song by Meghan Trainor. My name is no. My sign is no. She's laughing because she's a kid. The rest of you don't know the song, probably. You don't. See, when you have little grandchildren, you become a rock and roll lunatic all over again. And I am. Yes.
Has any state imposed a more meaningful penalty other than taxpayer money gets to go to pay lawyers?
Oh, yeah.
I mean, like money that comes out of the pocket of the
Oh, yeah.
people.
But they don't usually work because judges don't penalize their friends.
What's the toughest penalty that you've seen?
I don't know, there are penalties which might call for a fine, out of pocket. There are penalties that call for jail. I don't know of any government officials who have gone to jail for failure to comply with the open meetings law. And there are some places where, in Florida, if there are two school board members riding their bikes and they stop and talk to each other, they're violating the open meetings law. Did they go to jail? No, because it's silly. It's plain old silly. It's plain old silly. And legislative bodies often just don't think it through. What can I tell you? More questions? Come on. Anything.
You mentioned the two people. I've talked to some board members here after they did a downsizing with Kevin gone, and they trimmed a lot of boards from 5 to 3, and they complain, and they use the open meetings law as a sort of an excuse, a complaint that, it's so hard to do our jobs now because we can't even meet 2 people without having a quorum.
That's not true. If the board is 7, 2 people can do whatever the hell they want. The law applies only when there's a quorum. Even, in that situation, do you remember what I said back in the olden days when they moved from a 5-member to a 3-member board? I was called, probably by the Buffalo News, and I said, that's ridiculous. And the Secretary of State called me and said, don't say that. And the News called again, and I said, that's ridiculous, because it is. It's the reverse of meatloaf. 2 out of 3 ain't bad. If we're talking about the open meetings law and there's a 3-person board, 2 out of 3 is a quorum. They can't talk to each other. It is indeed ridiculous. And the thing to do, in my opinion, is not to quit. It's to say, let's change the law and make it 5 again. And I think some of them have done that. Some of them, at least one. Silly, silly, silly. Again, that is evidence of the failure to abide by the Aretha Franklin principle. You remember that one? You remember it? Oh, geez. You better think. You better think. It's not respect. It's you better think. They didn't think it through. And that's probably what I said then. You weren't there. Yeah.
How do you think the media is doing these days with the consolidation of media over time? Are you getting more meaningful questions, more questions, fewer questions? What are we missing?
In a lot of instances, I am getting more questions, which surprised me. It surprised me. I think it's because there are more media outlets than there used to be. In New York City, it's not just the Times and the News and the Post. There are any number of online or weekly publications, and they have filled in the gaps that have been left by the dailies. Realistically, if you live in Queens and you want to find out what's going on in your community, you don't read the Times, you read the Queens Chronicle. If you live in Elmont, you read one of the Richner publications. They have a whole slew of weekly newspapers on Long Island. When I was growing up, Newsday's slogan was, Newsday is Long Island. Not so much anymore. Newsday was the source. It was the source, and they covered everything. It was this thick every day. Now, the Newshold is not quite what it used to be. I think that they've improved of late. They've brought in some investigative staff who I think are really quite terrific. They've been somewhat aggressive. They've brought suits under FOIL and won and gotten attorney's fees. So I think that they're trying. But it is simply different than it used to be. But New York City, who do I hear from? Is anybody familiar with DNA Info? DNA, because it's like you, right? DNA Info has outlets throughout the city, and they have essentially neighborhood reporters, and people need to find out what's going on in their communities. In Albany, if I want to find out what's going on in Delmar, Times Union is really not the place to be. It's the spotlight, the Delmar spotlight. It used to be that people who worked for weeklies, they were stringers. They were, they got, whatever it was, 40 cents a line or something like that. Now they're graduates of the Columbia School of Journalism. It is just different, and you really have good young professional journalists working in so many of those places. So, yeah, things have changed. The dailies don't cover the news the way they used to. You probably know that in Syracuse, there's no daily newspaper anymore. They publish, I think, 4 days a week or something. That is tragic in a metropolitan area of 700,000 people. How can it be? How can it be? On the other hand, I know in Albany, the circulation of the Times-Union has actually gone up, in part because of the way the newspaper is run. I think that they do things reasonably well. And the other reality is, Albany, state capital, it's filled with political junkies. And that's what they cover. That's what they cover. There are things that appear on the front page of the Times-Union. Nobody gives a damn about 50 miles away. I mean, that's the reality of it. You're getting up. Time is up. Time is up. More questions? Come on. Anything. Anything. Nothing, huh? Thank you. My last words are, if ever you think we can help, please get in touch, use the website. We'll be more than happy to do what we can. And I thank all of you.